Yes, Mr. Cavender.
Good afternoon, my lords, my lady. May I now continue with looking at the proper interpretation of Article 221? You've obviously looked at the provision this morning. It is in primary volume, tab 3, starting at page 419. And keep that open for the moment while we're going through it and listening to my submissions. In my submission, the Member States' power under that article is governed and constrained by EU law in three distinct respects. The first, that the power, this is obviously under Article 2214, must be exercised for its proper purpose, namely to apply an extended limitation period to deal with acts which were liable to give rise to criminal court proceedings, in inverted commas. Secondly, the power must be exercised under the conditions set out in the provisions in force. And thirdly, the power must be exercised in accordance with general EU law obligations, including the principle of legal certainty. Firstly, as we saw in FII, para 44, rules that involve negative consequences for individuals should be clear, precise, and their application predictable for those subject to them.
Yeah. And the premise of all these submissions is that, properly construed, paragraph 4 implicitly confers a power on member states.
Indeed.
Yeah.
And the second EU law obligation is that it's set out at paragraph 31 of Velo Service, which is the tax position of the taxable person, having regard to his tax position vis-a-vis the customs or tax authorities, should not be open to challenge indefinitely. So what we say,
it's a power, but it's deeply built into a set of quite important duties.
Yes.
Which is to recover is to get the account right and to recover the duty.
Well, my lord, it's the ability for the member state, if there are difficulties with recovering debts of a certain type, and the characteristics described in sub 4, for them to enable them to apply an extended limitation period. It is an enabling provision. It's not a harmonising provision in any sense. It doesn't require a member state to do anything. It may, in provisions containing conditions, do a certain thing for a certain purpose. Purpose being an extended limitation period to be applied if, in the circumstances where criminal court proceedings are a possibility.
And you say, indeed, that the operation of paragraph 4 is conditional upon the exercise of that implied power.
Indeed, I do indeed. And you've not heard from my learned friend anywhere as to where he says the provisions are or where the conditions are. And that's an important omission in my submission. So with that as the opening position, let's look at the code and go, if we can, to page 420 to look at the meaning of customs rules. You haven't looked at this. So 420 Article 1. Customs rules shall consist of this code and the provisions adopted at community level or nationally to implement them. I concentrate particularly on nationally to implement them. So it anticipates that there are national rules that may be involved to implement the code and the provisions. We then go to, and my learned friend took you to page 424, the definition under sub 23, provisions in force means community or national provisions. So we take national provisions there and look back at Article 1, nationally to implement them. In my submission, the context and direction of travel for the construction is reasonably clear. We then go to Article sub 4 itself. And we ask the question, through the EU lens of legal certainty, it says may, but it envisages clearly that there will be provisions in force and conditions contained in with them. For what purpose? For the purpose of providing an extended limitation period.
Well, there clearly are a lot of national provisions in the UK dealing with the administration of customs duties and their collection. And we've seen that there is a specific provision disapplying the ordinary statutory limitation regime. And you would say that that particular provision is incompatible with EU law.
Well, I'm not sure I would say that, because the way I put the argument is, it's not incompatible with EU law. If a member state decides not to enact anything under sub 4, it doesn't have to. So therefore, there's nothing within the Limitation Act that is unlawful or contrary to EU law.
So you would say that Section 37 of the 1980 Act isn't a provision of national law of any relevance to paragraph 4. Is that what you're saying?
No, I'm not saying that.
No?
But
I'm having difficulty working out what you are saying now.
well, it is, of course, a national provision.
Yes.
And so it has relevance in that sense. But it's not unlawful, because there's nothing in sub 4 that compels the member state to do anything. So that's the difference.
No, but the member state has done something. It said that the ordinary limitation regime is not to apply to the recovery of customs duties.
Indeed. But it hasn't decided to enact under 4 provisions in force that give rise to an extended limitation period. That's what it's not done.
Well, it said, well, the effect of Section 37 is that there is no limitation period. Recovery can be done at any time, indefinitely.
Indeed.
On its face.
Indeed.
And that's incompatible, you would say, and I think Mr. Beale would agree, with EU law.
Well, the way he puts it, as I understand it, is that on disapplication, that once you construe this 4 of disapplying 3, you have nothing. In that world, the argument goes, having no limitation period at all may be unlawful. And in that situation, maybe you start to get the argument on its feet. But not when you view this as a power. It's only when you get to, and you take a board and you say, yes, he wins. This is a disapplication case. But my lord, the problem with that is the idea that EU law would construe Article sub 4, knowing the nation's member states not put in place any provisions, and say that therefore I'm going to construe it to create uncertainty. I'm going to construe it to create a lacuna, which we see in the reasonable time cases. My submission is not a proper approach to the construction of an EU provision. And what I say really is that my learned friend seeks to really ignore the words under the conditions set out in the provisions in force. It's almost if you take those out, so it reads, where the customs debt is a result of an act which at the time it was committed was liable to give rise to criminal court proceedings, the amount may be communicated to the debtor after the expiry of 3 years. That's the net effect of what he's putting forward.
No, in the particular circumstance that there are no local provisions.
Well, yes. Well, which there aren't here. The other thing my learned friend says is that the conditions referred to there relate only to the manner in which the demand is communicated, where there's nothing about Article 4, which is clearly giving rise and dealing with the provision of an extended limitation period, to suggest the conditions in the provisions are dealing with the manner of communication, still less that they were limited to the manner of communication. So after all, the conditions provisions are in the context of providing a power to provide an extended limitation period. And we get that also from AGRA. If we can turn to that, as one of my learned friends' authorities, that's in authorities prime bundle, tab 7, page 542. This is obviously dealing with the code and what 2214 is doing. It's paragraph 34 at page 554. Paragraph 34 says, secondly, it should be observed that merely by referring to the conditions set out in the provisions in force, Article 2214 of the Customs Code refers to national law as to the rules, focus on that, rules governing the extinction of the customs debt through the passage of time. So that's clearly saying what 2214 is doing is dealing with rules that deal with the passage of time, not the conditions and whether you send a letter with a heading or not, or whether you mention 2214 or not. So that, with respect to my friends, it's completely against him on this point. The other case he relies upon in this connection, my submission wrongly again, is the Mullen-Bernati case, tab 11 in the same bundle. If we return to that, my own friend took you to that briefly. One sees, if one goes to page 692 of that judgment, 692 of the electronic page, the four questions that were outlined to the court in that case. So 692, question 1 deals with applicability, 2 deals with entry into the accounts, question 3 is a limitation question, and question 4 is the relevant one here, which is the manner of notification. Nothing to do with limitation period. The limitation question is question 3. Question 4 is a question dealing with the manner in which the debt is communicated, not the time during which it is communicated. And what we see, if we go to where that is dealt with at page 700, where the answer to that question is given, what we see is dealing with member states required to determine the procedures. Does one see that word in para 50, page 700? Procedures in accordance with the notification must be made. Now that's clearly a reference back to Article 2211. If you go to page 685, where the code provides, as soon as it's been entered into the accounts, the amount of the duty shall be communicated to the debt in accordance with appropriate procedures. So if you go to 685, you see Article 2211. That's what they're dealing with. It's the manner of communication. It's got nothing at all to do with the time in which communication occurs. So returning back then to page 700, the fourth question. By the fourth question, this is para 50 now, the National Court is essentially asking whether member states are required to determine the procedures in accordance with. There's nothing to do with limitation. This is to do with manner of notification. Para 51, Belgian government talking about, third line, can they do so only a document referring unambiguously to Article 221. So they're talking about formalities. Nothing there. So when one goes to para 52 in the passage my learned friend likes about general principles not include common rules to affect them, national rules implement community rules, it's got nothing at all to do with limitation. So, my lord, that, in my submission, is the question of construction. It's quite a short point, really, is that it's for member states, if they want to use the power, to use it, and when they do so, they must do so in accordance with EU law, including the principles of legal certainty. And what I'm going to do now is show you a number of cases where this principle has been considered, and that bear out the construction that I urge upon lordships.
But could there be a sort of middle position on this, that you're saying that if you're relying on jurisprudence as the giving legal certainty to the length of time within which the taxing authority may make a claim, that has got to be established jurisprudence rather than jurisprudence which is yet to be developed?
Lady, yes, certainly. And the reason for that is because one of the cardinal parts of the legal certainty rubric is foreseeability. And we'll see in Fleischhandel in a moment. The reason there the court couldn't approach it by saying, well, we think 10 years is reasonable. The fact it's reasonable is irrelevant. It's foreseeability fixed in advance. This is the cardinal principle that my learned friend submissions don't begin to deal with. And so you must know in advance the limitation period that applies. That's part of legal certainty. So can we go then please to zu Fleischhandel, primary authorities, tab 15. My learned friend gave you a little taster of it.
Well, we had, as it were, a menu of options presented to us by Mr. Beale, and at least one of his options was one which which fixed a period in advance. That was to say that 2214 is referring to national law relating to limitation, as AGRA tells us. You look at the British law on limitation, and Section 37 of the 1980 Act disapplies it. So in order for anything to be done with British law to introduce a limitation period, you have to disapply Section 37. The minute you disapply it, Section 32 applies, and that gives you a fixed period of 6 years, extendable in the case of concealment, which would meet the requirements of legal certainty. And that provides you with an EU-compatible solution.
Well, the reason that argument doesn't work is that is not foreseeable to a taxpayer.
Why not? Why not?
Well, because the taxpayer looks at the code and he says 3 years. He then looks at whether the revenue have enacted any provisions, like they have for VAT, like they have for anything else, and there aren't any. So that's what he foresees.
Well, in reality, the taxpayer goes to his accountant or his solicitor, and his accountant or solicitor can be expected to be aware of a Supreme Court judgment which has held that Section 37 must be disapplied to the recovery of customs duties.
But he won't know that back in
No,
2004, whenever it was.
So that's true. That's past brainful. But once a decision is taken by the court, there is a regime in place which is predictable.
Well, it is, and of course in the decision in zu Fleischhandel, they said just that there's Article 195, I think, of the German Code, applied more generally, 20 years. Seems quite a long time, but it was not as foreseeable as a specific provision, but was adequate. But, my Lord, the suggestion that my learned friend puts forward and you articulate to me would not meet the requirements of foreseeability. No one would have known that.
But that's true of almost every case this court decides where we develop the law.
Not involving time limits and legal certainty, my Lord. If you remember, even back to FII and M&S, that whole line of authority is based upon the premise that people know in advance of fixed time limits. That is the very the basis of those authorities, and I'll show you these in a moment. You'll see they're based upon the same principles. So if we may, to zu Fleischhandel, which is in the volume, tab 15.
But you're really saying, you're coming to us with a problem and saying, there's a problem with the UK legal system here, because it doesn't fix a time limit.
It does.
And the court can sort that, it might seem to us, but you're saying it's in its very nature, it's an unsortable problem.
Well, no. Let's take your argument at its highest, which is that you're against me on construction, and then we're in a disapplication case. What do you then do? Because there's no time limit. What you then do is say, well, you must protect legal certainty. The only way you can do that is by applying, by analogy, the 3-year period that the code already applies for the recovery of customs duties. So that, in my submission, would be unobjectionable, and it would be it would satisfy legal certainty. Once you can go much beyond that, it is not predictable or foreseeable. Whether or not your lordship's suggestion, in my learned friend, is could you attach a date of knowledge to the 3 years, is a moot point. That wouldn't be foreseeable either, but it would be less reprehensible in some ways from articulating the principle I'm putting forward than saying, well, let's rewrite it. Let's have 6 years and let's apply 32(1)(c) to it. But let's go to Zuflishan, because this does answer some of these questions.
Just before we do, can we think slightly more deeply about the reason for this disapplication of the 3-year period in circumstances where, as it says, criminal proceedings are involved? I think it's common ground. It's not dependent upon proof of a crime. And it's primarily designed, isn't it, to bring this part of the tax code in accordance with a general understanding that criminal matters are for member states, and that therefore there is a constraint in pan-European regimes interfering with criminal matters. If that's right, and tell me if it's not in a moment, it might be supposed to be a little bit surprising just to find another slightly longer fixed limitation period in which the real concern would be the extent to which the need to pursue a customs reclamation claim might interfere with concurrent criminal proceedings which in many member states might be thought worthy of giving precedence. So that a much more flexible approach to when you could reinstate your civil claim might be appropriate in a particular member state.
Lord, I think you're giving criminal proceedings in that stance, the capital C criminal, as opposed to, as we've seen, 167 of the TMA here, we're talking about simply putting in something that's incorrect.
That happens to be a particular criminal procedure in one member state, but interpreting this in an independent way, one's looking at the whole gamut of potential criminal proceedings, isn't one?
Well, that is, but if you then look at your lordship's questions through the prism of the UCC, there it's expressly intended, potentially, that a fixed limit of 5 years, even in the case of criminality, would be within the aims of the code. You can extend it to 10, but 5 is the starting point. So there doesn't seem to be, in the background, some policy to which your lordship refers to somehow have criminal proceedings or quasi-criminal proceedings on one side and dealt with completely separately. Because the new code tells us that from the policy perspective, 5 years is seen to be a reasonable cut-off without any date of knowledge being delayed. So if one's looking for a policy objective of the type your lordship puts to me, one certainly doesn't find one there. Maybe we can come back to that. Can I take you to this case? Because this case does raise some of these points, and the answer of the court is quite instructive as to what they feel they can or can't do in order to engage with the principle of legal certainty.
I suppose on the approach being put to you, you would, in order for English law to impose any time limit, even if it's to be a reasonable time, for example, you would have to, in the first place, disapply not only Section 37, but all of the Limitation Act.
Yes, if you're going down the reasonable time route, indeed.
Yes, it wouldn't be enough to disapply Section 37, because then Section 32 would apply. So you have to disapply Section 32 and indeed the earlier provisions that actually
Section 9, dealing with under an enactment. But also you then introduce into English law something that's completely outside its background and DNA, which is a limitation period decided case by case retrospectively.
Yeah.
So it really would be beyond the pale in terms of legal certainty and foreseeability to do that.
Yeah. Yes, and I suppose, I mean, what the court's doing in a factor-tame situation is simply disapplying a provision of existing legislation which is incompatible with EU law. If the resultant situation is one that gives rise to problems, then Parliament can legislate in an EU-compliant way that meets the practical requirements.
But all of this, my lord, this is quite interesting, that rather than construe the provision as in my submission you should, through the certainty of law and purposive approach, and look at it as a power, which its words suggest, and look at it in terms of Article 1, talking about implementing national provisions. The way you don't do that, either you don't have national provisions and you don't implement them, that you stay with the primary period. That's what happens in Zuflischhandel. And there's all the same points you're putting to my lordship could have been put to the court in that case. That they say, well, how about a shorter period? 10 years is reasonable. And the court says, yes, but we're not here to legislate. That is not our purpose. And it would not be foreseeable to apply some reasonable time. Can we go to that? Because, as I say, it is...
Yeah, taking us to Susu Fleischhandel.
Indeed, my lord, yes. So that's primary authorities, tab 15. So this is under the Eurotom provisions my own friend showed you this morning. Page 772, one sees the context. If we go to 771 first, under legal context European law, the recital to the regulation, the preamble talks about dealing with acts detrimental to the community financial interests must be counted in all areas, at the bottom of 771. So it's the same idea of having the coffers of the EU being protected. And then we have, at the top of page 772, irregular conduct, administrative measures, penalties, etc. So that is wide enough to include fraud and the kind of things we're dealing with here. Article 1, sub 2, irregularity shall mean any infringement of provisional community law resulting from any act or omission by any economic operator. And then we see in Articles 3.1 and 3.3 of the regulations, limitation period of 4 years. And then over the page at 773, Article 3.3, member states shall retain the possibility of applying a period which is longer than that provided for in paragraph 1. So that's the setup. There are two references in this case. If one goes to page 776, one sees the relevant question from the first reference, just by way of background. And the question was, may a longer period be provided for under what was called a catch-all provision, i.e. existing law. One sees at the top of 777, yes, you can. The longer limitation period, member states retain the possibility of applying, may result from general provisions of law predating the adoption of that regulation. So that's the background. The second reference then you pick up at page 779. And there are three questions. The first is the application by analogy of the limitation rule in paragraph 195 of the German code, that's a 30-year rule, compatible with legal certainty? Second question is that applicable, top of page 780, with proportionality? And the third is, if the second question is no, it's not compatible, can we reduce the 30-year period to some other period? And the answers then follow at the bottom of 780, is that one can see, really picking it up in 22, the court was asked in the first reference whether a longer national limitation provision was within the meaning of the article or not, preceding. However, the court was not asked expressly about the subject of the present question, concerns the manner in which such provision is applied, determined not by the national legislation but by case law and by analogy. So what the court's saying is, we weren't asked this question. You may have thought it's implicit in the first reference, but it wasn't. We're now being asked it. And then in 23, if you cast right over that, you can see what's being said. And I'm picking up the bottom of 23. Provided, however, the member state in which the regularities were committed did not make use of the possibility offered to it under 3.3 of that regulation. So it's suggesting, which must be right, that there was a power there, an option of using the possibility. And 26, over the page at 782, we can see that the member states retain a wide discretion in fixing longer limitation periods. I emphasize the word fixing, 26, in periods. And then in 30, such practice is in principle permissible. However, that practice must still comply with the general principles of European law, including the principle of legal certainty. So yes, you can apply a longer period, but you must comply with legal certainty. Then para 32 is the most important paragraph, because what this does is set out the principle and cites various areas of law, not just about the Euratom provision, but throughout the European sector. So if you all could read paragraph 32 to yourselves, please. What I focus on in the middle is, consequently, a limitation period must be applicable to proceedings in respect of such an irregularity. And then the cases it cites, Aston Power's a VAT case, ACF Chemopharma is competition law, Marks and Spencer, of course, VAT, and Danske is an import ban. So this is a general statement of EU law applicable across the piece. It's not limited to Euratom, it's a general statement. Then go to paragraph 33, and they say at the bottom of that paragraph that a limitation, a period by analogy, is fine if it's a past judicially determined practice known to such operator. And then 34 is important over the page at 785. However, such application complies with the principle of legal certainty only if it results from a judicially determined practice which was sufficiently foreseeable. That's an important point in the debate that we've had earlier. And then at the end of 35, it may result from that practice sufficiently foreseeable matter for the referring court to establish. So that's what's said on question 1. Question 2 on proportionality.
There isn't a proportionality question here, is there? There is
Not expressing, my lady, but it's in the background, as it always is, that the principles of EU law hunt together, really. But no, but it's interesting what they say in relation to it, because it does refer back to the principle of legal certainty. So if we can pick it up at paragraph 45 at page 788. What it talks about is the 30-year period, end of 45, exposing operators first to a long period of legal uncertainty, and secondly, the risk of no longer being in a position to prove at the end of the period that the transactions in question were lawful. Now, that's the same policy objective that I outlined when I opened this morning. Then 46, in any event, a 4-year limitation period, such as that provided for in the first paragraph, if that were to appear from the national authorities' point of view too short to enable them to bring proceedings in respect of irregularities displaying certain complexity, it would always have been open to the national legislature within the framework for the possibility provided in Article 3.3 to adopt a longer limitation rule, emphasise rule, suited to the irregularities of that type. Of course, the same applies here. So that's the proportionality question. Then question 3 is, if 30 is too long, can we reduce it somehow to make it proportionate? And that starts at the bottom of 788. And then para 50 on page 789 say this: nevertheless, in a situation such as that an issue in the case in the main proceedings, it must be stated in any event, the absence of legally applicable national legislation laying down a longer limitation period, Article 3.1 provides for a 4-year limitation period and remains directly applicable in the member states. And in my submission, that is the result that should happen in our case. In the absence of any enactment under Article 2214, you go back to the enacted provision. And then over the page at 52, the court is asking itself, well, why can't I apply a reduced period that's reasonable? So this goes to my learned friend's reasonable time submissions as well. So in such a situation, national court are allowed in the context of regulation to reduce the limitation period applied hitherto down to a level capable of proportionality, etc. This would run specifically counter to the principles that first, in order to fulfil the function of ensuring legal certainty, a limitation period must be fixed in advance, Marks and Spencer, and secondly, any application by analogy of a limitation period must be sufficiently foreseeable for a person. So in my submission, what this case is helpful in dealing with is that it applies the principle of legal certainty to limitation periods enacted in national law which are used in support of EU law, same as our case. That existing non-specific national laws, like Section 195 of the German Code here, can be used for this purpose by analogy, providing their application is foreseeable by reason of early judicial rulings, but not otherwise. The challenge is on a systemic basis, not a case-by-case basis. Now, in my submission, that authority and the reasoning within it makes the idea of applying a reasonable time type limitation period very difficult indeed, as found here by the Court of Appeal. Because that's effectively what my learned friend is seeking to do. True it is they're dealing it here in the context of legal certainty and proportionality, but the same principle applies generally. Because as Lord Sumption said in FII, as I said, legal certainty is at the heart of the EU legal order. And what Fleischhandel tells us is that the principles of certainty apply, whether the national law specifically applied under a provision like 2214 or here Article 3, or whether it is an old provision in the background that you're using for that purpose. Either way, it has to be subject to the legal certainty criteria. And the result in Fleischhandel was they had to revert to the primary period of 4 years.
But the primary period in Fleischhandel was one which Europe had concluded was a perfectly suitable period for the circumstances, which was dealing with irregularities.
Right, and it was saying that...
Whereas in this case, the primary period is a general primary period, and 2213 introduces, well, what happens if the underlying issue is subject to appeal? And 2214 introduces, well, what happens if the underlying question may be the subject of criminal court proceedings? In other words, one's prima facie into a situation where it doesn't require very deep construction of the article to see you're in a situation where the primary period may be prima facie inappropriate.
Well, it certainly is, as I put it, there are three conditions on the power. You're in a position where you're entitled to enact another provision to deal with that. The question is whether you do so, and if you do so, whether that complies with legal certainty. And in my submission, there's no answer to that case when you apply that to this case. It's very similar regulation. It's dealing with the EU funds, so the same points of principle of policy are involved. It allows for an extended limitation period to be provided, but where you don't have to. And what it's saying is that that is subject to legal certainty, and if you do not enact an extended period subject to legal certainty, we won't help you by reading down or reducing to a reasonable time such limits as you do have, because that is effectively enacting a new limitation period, and that would not be foreseeable, and that would therefore be objectionable under the principles that we've seen. The next case I want to take, if I may, is Firm East Colmar, Additional Authorities 2. Page 45. Sorry, tab 45, page 1369. Now, this dealt with the same regulations we've just been looking at, and the issue here, we can pick up from para 20 at page 1373. Was when the limitation period commenced, and it was when prejudice had been suffered. That was the background to it. The point I want to take you to, if I may, is to the AG's opinion in this case, which one finds at page 1384, para 30. Sorry? 29. My loan friend wants me to read, or for you to read to 2029 as well. I'm not quite sure. I think he took you to this. But so 1384, I want you to read 30. My friend wants to read 29 as well. I didn't go to The point I want to refer particularly is the last three lines of 30. Always be able to the national legislature to adopt a longer limitation rule suited to the irregularities of that type, which would need to meet the requirements of foreseeability and proportionality deriving from the principle of legal certainty. So that's the principle I seek to get out of that. If I can then take your lordships, if I may, on the same point to a case called Velo Service, my own friend very briefly mentioned. This is going back to the interpretation of the code in these proceedings, page 761 of the bundle. And what this concerned is particularly Article 78 of the code. One sees that from page 762, which deals with the possibility of revision of a declaration based on incorrect or incomplete information. One sees that from Article 78.3 on page 762. The thing about that to bear in mind is that that's a revision possibly upwards or downwards. It could result, obviously, in a payment back to the trader or a payment from him. And you can see the problem in this case, one sees at the top of 763, is a Latvian law national provision under paragraph 5 there, that provided that the decision of the inspection would be final. So there's a national restriction there. There'd be a single inspection, and you couldn't then revise that. And yet Article 78.3 appeared to allow you to have a revision up or down. So that was the context involving some importation of some bicycles. Now, the result was that whilst Article 78 permits member states to do something to re-examine the customs declarations, nonetheless, the exercise of that power must comply with EU law. That was the result in the case. Can I take you and ask you to read para 19? Because this refers back to my Article 1 point about implementation of national provisions, where the court says this at para 19, page 765. It's moreover clear from both Article 1 of the Customs Code, according to which EU customs rules also exist for the provisions adopted at national level to implement it, emphasising those words, and from the court's case law, that whilst the member states retain the power to provide for procedural rules in the scope of the Customs Code, they must also ensure they comply with the Customs Code and more generally the requirements and the relevant principles of EU law. So, and then 20, subject that provides the member states in principle retain jurisdiction to adopt rules governing post-clearance provided 78.3. So 78.3 didn't provide any limitation period of revisions. So that's the background to it. So then 28 over the page at 766, it follows Article 78.3 must be interpreted as meaning that within the framework of the obligations, as a rule, authorities to revise or conduct post-clearance examination of customs declarations and to regulise the situation. However, 29, they must do it under legal certainty. 30, must be recalled the principle of legal certainty and protection of legal expectations, form part of the EU legal order, must be observed not only by EU institutions but also by member states, in exercise of the powers conferred on them by EU rules, so too here. First of all, according to the court-settled case law, the principle of protection of legal certainty is aimed at ensuring foreseeability of situations and legal relations, and requires inter alia that the tax position of the taxable person, having regard to his rights and obligations vis-à-vis the tax or customs authorities, not be able to challenge indefinitely. This is a provision, a part I obviously rely upon heavily. Then in 33, you see Article 78 of the Customs Code does not lay down any time limit for post-clearance examination, and member states are free to make that procedure subject to a reasonable time limit. Now they say that, of course, because that could go either way, go up or down. Then in para 36, given that once the 3-year time limit from the customs debt was incurred has expired, it's no longer possible to communicate a new customs debt and thus regularise it within the meaning of 78.3, the principle of legal certainty requires member states must be free to limit the use of the procedure provided for under that provision after expiry of the 3-year period on the date in which the customs debt was incurred. During the 3-year period, some member states' rules must, as observed in paragraph 25-28 above, allow the customs authorities once again to take measures to restore the situation, etc. And then it says, it must moreover be possible to take such a measure even after the expiry of that period in a situation where the customs debt is a result of the meaning of 2214. Now, in my submission, what they're clearly getting at there is, in the case where there's an extended limitation period, where someone has exercised the 2214 power, then the power under 78.3 will also operate within that period as well, as night follows day. It's saying no more than that. And the point about the up and down point is also borne out by para 38, where it's observed in the second half of 38, page 767, at the very least during the 3-year period from the time the customs debt was incurred, since observed by the Commission, revisions and post-clearance examinations do not necessarily affect the legal position of the taxable person. What they mean there is affect negatively, because it might be a repayment to the taxable person. So what you get from this is, firstly, in para 19, Article 1 point about implementing in national provisions, you get that Article 2214 has to be exercised in accordance with EU law rights, including certainty, and that includes foreseeability. The next case I was going to take you to was Agra, again in the same bundle, tab 7. My own friend's taking you to this. I've already referred you to page 554, para 34, about the passage in time.
And
rules governing.
And perhaps also paragraph 35.
Lord, yes, that's what I was going to go to now. So it says, according to, insofar as EU law does not lay down common rules in this field, it is for each member state to determine the rules, I emphasise that rule, governing the extinction through the passage of time of customs debt which has not been possible to assess because of an act can arrive to criminal court. And I refer then to Hannel Hofstetter, which you have in additional volume 2.
Just before we look at it, if one of the possible approaches that Mr. Beale was canvassing with us in his submissions was that it might be that, as in the case of the authorities that we looked at concerned with state aids, there might be no rules under which the debt was ever extinguished, but there might be rules but there might be a general principle that the debt could not be recovered where to do so would violate a legitimate expectation of the person in question. So, for example, if the authorities had delayed for a protracted period in taking any steps to recover the debt, and had engendered a legitimate expectation on the part of the person in question that the debt was not going to be recovered, then they might be barred from recovering it by the principle of protecting legitimate expectations. And that has also been canvassed by some members of the bench. Now, on one view, it might be that paragraph 35 is difficult to reconcile with that approach.
Well, my Lord, I think it is, because legal certainty, as Lord Sumpter in FII, is one of the three, the effectiveness and equivalence, proportionality and certainty, gets less mention. But as he said, it's the centre of the legal order, and legal certainty itself has different bits as a principle. So one of them is the point you've just put to me, is that if you sit on your hands as the member state or the commission and you let people believe they're entitled to the money, legitimate expectations may arise. Yeah. That's not the whole of legal certainty. Legal certainty also is engendered by the principles of fixed time limits and foreseeability, which are allied, but they're slightly separate and distinct. And it's those parts, my Lord, that I advocate in this court, in this case. And it's those parts that Zuflischhandel and Velo Service are very fixed upon. And if you look at paragraph 35 and Hannah Hofstetter, if you go to the case, which you'll find in Digital Volume 2, tab 49, page 1520, they make clear at para 18, page 1520, that if you're going to introduce penalties, this was about, they must be in accordance with the principles of community law. So there's no doubt at all that you read into para 35 that if there are no common rules, the member state can do so, but they do so subject to fulfilling community law principles. So in my submission, the Zuflischhandel and Velo Service jurisprudence is directly applicable to the issues for your lordship, and does, as the Court of Appeal say, make the matter act clear in their view. You've not really heard from my learned friend yet in my submission anything that really begins to suggest that they don't apply. My Lord Briggs puts to me, well, FII is all very well, but doesn't take us that far. But when you look at FII and the principles built through Zuflischhandel and through Velo Service, and you then look at this provision and say, what does it mean for construction, and B, how is it operated, pursuant to those principles of legal certainty? In my submission, the answer is tolerably clear. So we then go to the reasonable time part of my learned friend's case. That effectively, although there are problems of legal certainty, my learned friend has to sort of put his hand up to at least in part on that. He says that's met by the reasonable time principle, doctrine, theory. Now, the first answer to that is, if legal certainty is engaged here, and in my submission it is, it's fully engaged. So all the principles of legal certainty in Velo Service and Zuflischhandel and FII apply. Having a certainty light, if I may put it like that, a little bit of certainty, some certainty through the reasonable time provision, does not begin to meet the requirements. So that's the first point. The second point is, my learned friend has not cited a single case to you where this so-called principle has been invoked in a situation of a member state under an EU regulation against a citizen. They're all cases in terms of the Allen line of authority, the intra-institution, and in the state aid position, of course, it's a decision of the Commission in relation to state aid. Again, so within the Commission and the European family, put it that way. And what the provision in the reasonable time, the Allen provision, is this. If there is a lacuna, if there is no provision anywhere in the legislative spectrum, then as an emergency measure, and that's the word used in an AG opinion I'll take you to, rather than throw your hands up in the air and say, I can't do anything, the court will introduce some degree of legal certainty by invoking this principle. It doesn't apply, it's never been applied, we haven't seen a case where it's applied, to a member state under a regulation in the kind of context situation we're dealing with, which is very different. The cases we'll come to in reasonable certainty, so reasonable time, are provisions where people are suing the Commission, employment cases, cases for damages, things of that kind, and then the two state aid cases. They're a million miles in context from what we're dealing with here. So it's also the case that I don't, as I said earlier, know what the case on reasonable time really is. It hasn't been raised by my learned friend to the Court of Appeal. There are no findings on it. He says that it's on a case-by-case basis, but we're now in the Supreme Court. I still don't know what the reasonable time is. I don't know how it's going to be calculated, or by reference to what. What we do know, in terms of when we go to the facts and issues, if one takes up the core volume bundle and goes to page 57, 58, you'll find a table there. At para 2 at page 57, you'll see the relevant demand was on the 1st of April 2011. Sometimes people say it's 30th of March, but whatever it is. But then you go to the table at the bottom of page 57, and you see the date of the first import is August 2003. Now that's some 7.5 years after the date of the relevant demand. And then the youngest, if you like, 20th of January 2004, is 7 years and 1 month. The other point I should make while we're on this document, my own friend says in his written case there's no appeal against FMX 1, but of course there's no limitation in FMX 1. I'm sure Lordship's picked that up, but there was no limitation issue in FMX 1. So the second point about reasonable time is that it fails to grapple with the jurisprudence I've just been through. It doesn't begin to meet it head to head as a principle. It just seeks to say, well, there's another principle over here. It doesn't begin to say, how does that begin to meet Zoo Flash Handle and Velo Service and FII? Because it's an odd argument, because if a member state does exercise the power under 2214, then the time limit chosen will be subject to the full force and effect of the certainty of law. That seems to be accepted. But if a member state chooses not to exercise the power and does nothing, so there's an absence, that member state is somehow better off because it can use this reasonable time principle that is not foreseeable, has never been used before against a member state, and produce a massively uncertain and therefore a contrary to EU law principle. Because this is not a case where there is a lacuna in the legislation. There is a 3-year fixed time limit within the code, and there's a power within the code to do something else if you want a longer period. So it's not a case, as the reasonable time cases are, or the state aid cases, but there's nothing. This is within the machinery of provisions that are there. In many ways, in my submission, the approach of the revenue is to interpret 2214 in such a way as to create a lacuna, to create a difficulty, and then use the reasonable time provision to seek to say, well, this is satisfactory. It may not be wholly satisfactory, but it gives you some degree of certainty, certainty light, as I have called it. But they do so without answering how that begins to meet Velo Service or Fleece Handle, and in my submission is artificial in the extreme. Can we then go to Saunders and have a quick look at that?
Sorry, two.
So Saunders, the first
Thank
of
you,
the
yes. Yeah.
reasonable time cases. One sees that in the Supplemental Authorities volume, tab 59. And this was effectively an employment case seeking damages on the basis of discrimination. So quite a long way from the area we're dealing with, which is a claim for reimbursement, effectively, of a tax. And this is a principle one sees at para 60.
Can we have a page?
1727, my lord?
1727?
Yep.
Thank you.
Para 60. For community institutions, the duty to act within a reasonable time is an aspect of good administration. So we're talking about community institutions, firstly, and good administration. And it derives from the need for legal certainty. So quite some distance from what we are dealing with. Then we go to definition of reasonable period, it's 1729 and following. And 71 is quite an interesting paragraph, because and my friend, I'm not sure referred to this part, is that the last three lines tell you what kind of legal certainty they're involved in. They say this: the legal certainty, which it is the purpose of the requirement of an action within a reasonable time to safeguard, is thus essentially for the benefit of community finances. Pausing there, the legal certainty I'm talking about, advocating here, is not about community finances. It's about fixing in advance foreseeable time limits. And so this principle in this area is, in my submission, in a very different area at all. The legal certainty I'm asking about is to protect the taxpayer from demands without limit in time, and to make time limits in which they must do so predictable, clear, and fixed into advance.
I don't quite see why that's not in the same policy area as protection of the financial interests of the EU.
Well, they both obviously have an impact on the finances, my lady, yes. But what wasn't an issue here was that the aspect of legal certainty that I'm particularly focusing on. I've said it's a number of aspects.
Yeah.
It's not...
In this case, it's true that the requirement for certainty isn't that which protects the community's finances. It's the requirement to dispense with the default 3-year period which is designed to protect the community's finances, isn't it?
Well, it's the ability...
Whilst criminal proceedings may make it impracticable to protect the community's finances until the proceedings are over. As in Agraware, it was thought that maybe you should have a time period that starts to run when the criminal proceedings are finally over.
Indeed. Lord, that's certainly so. But I'm not sure where it takes you within the reasonable time.
That's why I'm asking.
So the second case is Nencini. So this is Authorities Prime, tab 12, page 723. So this was the same fact pattern. So there was another group of employees trying to do much the same. No, this is the expenses case. So this is the MP, sorry. And it was a question of the interaction of the two regulations and the commencement. My little friend took you to most of the bits that are relevant here. The bit that is helpful, I think, is the AG, which again my friend took you to, but I want to put particular emphasis upon. So this is at page 737, first of all, at para 81. The bottom, the limitation period and all the arrangements for its application must be established and known in advance. Moreover, the introduction of the limitation period makes it necessary to determine all the conditions surrounding its application. Then in 80, before that, I should have said, in my opinion, the establishment of a limitation period is a matter for the legislature. So what we're talking about is not a limitation period at all. This is something different. This reasonable time thing is not a limitation period. It's something about good administration. And then over at para 93 and following, so page 738, 96, under EU law, this role of an emergency solution in regard to a legal relation between EU institutions and private debtors is, in my view, most adequately fulfilled by the reasonable principle. Now, pausing there, this emergency solution, this is only created by the construction my learned friend urges upon you. You don't have that emergency situation or lacuna in other cases if you construe it in the manner that I urge. So this is dealing with a different context, a different situation, saying there's nothing here to help me. Legal certainty has to do something, it does reasonable time. In the situation we're in, we have a code that tells us 3 years. So we've got help. We don't need to legislate. We've got the 3 years. And even if we disapply, even if your lordship is against me and say, no, it's definitely disapplication, we still look and we still have the 3 years there, as they did have in Zuflischhandel. They reverted to the primary limitation period. And then at para 99, he makes the point, the AG here, that this is certainty light. It isn't proper certainty. It's one aspect of good administration of legal certainty, where he says this: nevertheless, in the absence of an appropriate legal period, recourse to a reasonable period principle seems to me the appropriate way of ensuring that in a particular dispute, a legislative lacuna in the matter of prescription does not undermine the legitimate interests of a debtor of the European Union. But he says above that in 99, I must emphasise the application of the reasonable period is not likely to guarantee the same degree of legal certainty and foreseeability of legal situations as is the legally prescribed limitation period, duration of consequences of the expiry of which are determined in advance. So in my submission, that encapsulates really the debate that we are having. Then the state aid cases, again, that's Authority Prime, tab 9, page 571. This is back in 1998 now, so quite an old case about the supply of railway equipment. And here the BFM was seeking the annulment of the decision of the Commission that state aid given to Italy was contrary to the common market and legal. So again, an intra-EU dispute. And what you find, and depends which way you look at these points, at para 67,
page for that, please?
Page 591, to date, no limitation period has been established by the community legislature as regards the Commission in respect of non-notified state aid. Pausing there is a limitation period been established by the community in relation to the recovery of customs duties. It is 3 years. There are provisions that extend it if you wish to, but we're in a completely different field. Here in the state aid field, there is nothing. There is a blank piece of paper. And what it's saying in this paragraph is, it's not for us, it's for the legislature to set out a time limit. And they said there, under 68, over the page, they're not even willing to apply by analogy the 5-year period, because that's too much as well. That's too close to legislating as well. The same points can be made about the Italian Republic case. My Lord, have you finished with that? Shall I move on, or my Lord, are you seem engrossed in reading that?
No,
don't
wait
so
for me.
we go on to Primary Authority, tab 10, the second of the two cases, the Italian Republic case. Again, my learned friend took you to this. It's paragraph 82, I think, of that page 644. We see in the middle, paragraph 82, again reference to observing the principles of protection of legitimate expectation and legal certainty. And then if we go to paragraph 89, page 646.
Just before we leave 82,
Yes.
it appears that by this time there was a primary default limitation period
It had been introduced, but
of 10 years.
it wasn't retroactive, so it
No,
didn't apply
sure.
to the relevant dispute.
Understood. Yeah, not applicable.
So if we go to paragraph 89, dealing with limitation periods, in the middle of 89, page 646, it is sufficient to reply that in order to fulfill its function, such a limitation period must be fixed in advance, the fixing of its duration, the detailed rules for its application coming within the powers of the community legislature. On the date of the contested decision, the latter had not yet acted to fix a period of limitation in connection with the monitoring of aid granted under the treaty. Then over the page at 90, however, the fundamental requirement of legal certainty has the effect of preventing the Commission indefinitely delaying its powers. In that regard, a delay by the Commission in deciding that aid is illegal must be abolished and recovered by a Member State could in certain circumstances establish a legitimate expectation on the part of the recipients of no aid. This is my Lord Reed's point. But this is only one element of legal certainty, that you generate this legitimate expectation. It isn't the whole of legal certainty. It's not particularly the part that I'm praying in aid in this case. So in my submission, these two state aid cases are dealing, as indeed the reasonable time cases, in a completely different, distinct arena within the EU institutions amongst themselves, where there are no provisions at all, and rather than do nothing, some small degree of what I call certainty net is given. That does not begin to say that that is complying with the principle of legal certainty we've seen from FII through to Velo Service and through Flash Handle. It is a completely different thing.
Why should it make a difference that it is dealing with the EU institutions? Why should there be a difference between their position and the position of a member state acting within EU law?
Well, it's a good question.
Because you founded on it repeatedly. You've kept on saying the EU institutions. Why is there a different principle involved? I can see the different circumstances.
Exactly.
That's one thing. But why does it matter that it's been confined to EU institutions?
Well, the fact is that it has, firstly. The question I think you asked me is there any principled reason why a reasonable period couldn't apply outside? And I think the reason is that in those cases, you need to comply clearly with Velo Service, FII and Flash Handle. Those principles, if you like, have not bled into the institution cases. You have, if you like, two different lines of authority dealing with two distinct situations. And what a learned friend really says is, well, the reasonable time cases and the state aid cases somehow, and I don't quite understand how it gets there, supplant and dilute or infect the clarity of legal certainty one sees in FII, Velo Service, Flash Handle, when in fact what's really happening is that the state aid cases and the reasonable time cases haven't caught up yet. They haven't caught up and had the full effect of the more modern and full approach of certainty of law applied to them. And you might ask, why is that? Well, one of the reasons is, of course, is the reluctance of the courts or inability to legislate as to time limits. In a state aid and the reasonable time cases, the courts are dealing with a blank piece of paper with nothing to apply by analogy or whatever else. So it's a very different situation. In the present situation, there is a code, provides a primary limitation period. There are certain circumstances where you can extend that. That has not been done. So the idea you come to the aid of the member state and provide a reasonable time limitation period, which of course is a contradiction in terms, to assist them when they could have easily enacted a provision themselves, is in my submission slightly wrong-headed.
But it's a quite tendentious way of putting it. I mean, the member state is discharging an obligation to collect tax for the custom duties for the community. which will be credited to the community account. It's not doing something for its own benefit, it's merely discharging a duty.
Lord, that's certainly right. I think they retain 20% for the
Well,
fee
maybe,
accounting.
but the general structure of the code,
That's certainly
as
right.
is well illustrated by the opening provisions, are that it's actually all about member state obligations
Lord, yes. No, I wouldn't. I wouldn't.
for the community's account.
Indeed. No, that's quite right.
Well, one might describe this as why should we come to the aid of the community where a member state in a situation which the code contemplates may not properly be covered by the default period hasn't spelt out its own period, i.e. where criminal proceedings in criminal court may ensue.
Lord, yes, but it had the power to do it in my submission and hasn't done so for whatever reason. That's the position put neutrally. And the question is whether they don't. Do you infer a reasonable time? Is that a sensible EU approach to this? And is that a sensible approach based on the Nancy or Allen line or the state aid case line? My submission, it clearly is not. And to do so would be contrary to fellow service and Zuflischhandel. Zuflischhandel would be decided differently if my own friend's submissions were right. Because if you recall in Zuflischhandel, the ability to provide some other period wasn't, say, another limitation period fixed in advance. I mean, it could have even been another reasonable period. But they say, no, we're not engaging in that at all. If you don't use the provision and have some other national compliant provision, then you have to go back to the primary limitation period. We're not in the business of applying some reasonable time. We're not going to read down the 20 years in that case to 10 or 5, even though that might have been reasonable. We're not doing it. Why aren't we doing it? Because it would offend certainty of law of foreseeability of consequence. So, my Lord, those are my submissions on the state aid cases. And as my Lord Briggs noted in passing, that obviously was seen as not acceptable, and so they did enact a 10-year limitation period after this. GMAC and BT, my own friend, referred to that very briefly. Of course, that was a case where his reasonable time provision was rejected in 2 different Constitutional Court of Appeals on the basis there was no such principle, albeit it was, in that situation, tried to be used by the revenue against the taxpayer who had taken some time to, as bad VAT relief cases. So what he seeks to do in this case is resurrect his challenge, say, no, there is this principle, but he's using it in the other direction this time, and saying, well, this is something that can be relied upon the other way, implied inhibition on the making of a claim by the member state. And so because of that inhibition, somehow that makes more reasonable, more certain, which would be completely uncertain if you didn't have that. That is how I think the argument goes. And I'll say no more about it. So
Are you going to come on to Nencini? The reason I'm asking about it is, the reason I'm mentioning it is because it might be said to be more on point than the state aid cases, in that, in the context of state aid, there's simply no limitation period in play at all at the time of these judgments. And so the reasonable time requirement is at large. In Nencini, there was a normal limitation period of 5 years, which was inapplicable in the circumstances of the case.
Can we go to Nancy?
Yeah, and the court then took it said in that event you must act within a reason, must be a demand for recovery within a reasonable time. But in deciding what was a reasonable time, it took the 5 years as the starting point and said, well, you who was demanding the money, have to effectively justify the time that it's taken you beyond the normal period.
Lord, I'm not sure that's entirely right. Can we go to Nancy?
Right.
And
It's a case that I was studying, and
Right.
you may have read it for.
You
more
referred
carefully
us,
than
I
I
think, to the Advocate General's statements earlier in your submission, but I don't think we went to the court itself.
That is correct, Lord, yes. So can we do that? In the primary volume, tab 12, this is the MP case.
Yeah.
And there were two provisions
Page?
that were, it's page 726, my lord.
723?
726.
726, thank you.
And I think the best pick it up is para 36. So there are two provisions, Article 73A and Article 85B. Article 73A set down a limitation period of 5 years. That's called the financial regulation. Article 85B1 of something called the implementation regulation. So the limitation period shall commence on the expiry of the deadline communicated to the debtor in the debit note. Now the problem in the case was that there was no obligation on Parliament to issue the debit note by a particular time to trigger the limitation machinery. So so there were two express limitation provisions, but there wasn't a starting gun for the issue of the debit note.
Yeah, yes, the 73A is saying that entitlements in respect of third parties, etc., shall be subject to a limitation period of 5 years.
And then the date for calculating the limitation period and the conditions for interrupting this period shall be
laid down
implementing rules.
in the implementing rules, and those rules were effectively incomplete.
Well, they weren't incomplete. It wasn't sure when they would start. So, respect to a third party shall begin to run on the expiry of the deadline communicated to the debtor in the debit note.
Yeah.
So what there wasn't clear is when they had to issue the debit note to trigger. And they said, well, perhaps unsurprisingly in that case, well, it was easier to say, well, within a reasonable time, if you've got the debit note. So it's a slightly different case. And I referred, as my Lord Hodge reminded me, to the AG in this case earlier, and he refers here to an emergency measure to assist legal certainty. But it's very, very different in my submission to the present case. But it is true that they did use the not sitting on your hands administrative obligation to get on with things to aid them in that construction.
Yes. Well, look at their reasoning in 48 and 49. 48, in the last 4 lines, makes the point that if you simply read the text of Article 85B, the Parliament would be able freely to set the date of the starting point without any connection to the point at which the debt in question arose, which would run counter to the principle of legal certainty. And then in 49, they then take the 5-year period
And use it again effectively.
as a default. Yes, as a sort of
They use it
default
again.
period, and then you need to justify delays beyond that.
Lord, yes. But they're still using another period of 5 years effectively.
Yeah.
Again, this was a gap that had to be filled.
Exactly.
Yes. Yes, I mean, the reason I was thinking this might be of interest was simply that rather than saying, national court, over to you, you decide what's reasonable, and, one could just imagine a sort of how that might be applied. It's being tied to an EU norm here, so it's not reasonableness completely at large.
No.
You're having to justify any period beyond the default period.
Lord, yes. So it's internally referenced in that way. So, my Lord...
And that, of course, is exactly what was done on this very regulation, or approved in the Agra case, where they said you just reapply the primary 3-year period, but suspend the running of time until the end of the criminal proceedings.
I'm not sure
Well, that's sort of been done, and they said that was compatible. I don't think they said it was the only way to do it.
Sort of. I mean, the question there was whether it was lawful to have the postponement within the hands of the member state there, because they wouldn't have to start proceedings and things of that kind.
Yeah.
Essentially, Lord, yes.
But they said there was.
Yeah, there was, and that was fine in that case. They said that was compliant.
Yeah, so the running of criminal proceedings, for example, would be a justification for extending the 3 years by however long those proceedings took.
In Agra, that was the case, my Lord, yes, that was the effect. So then quickly, because I've only got literally a few minutes in my learned friends agreement on time, is ground 3, protection against stale claims, We've dealt with this in our written case at paragraphs 44 to 47. In my submission, if I'm right on legal certainty, then general principles of abusive process don't begin to help and provide for the gap of legal certainty. The equitable doctrine of late cheese, whether that applies in the tax tribunal at all, being of statutory origin, I really have some doubts. But again, it's not going to begin to fill the necessary gap, and nor will Article 47 of the Charter of Human Rights about bringing trials in a reasonable period. These are all things aimed at a completely different set of circumstances and not at creating legal certainty of fixing time limits in advance. So that's ground 3. Ground 4 is a disapplication argument. In my submission, Lord Hodge was right in his intervention with my learned friend on this, that there's no obligation on the member state to do anything. And indeed, that's of course the conclusion of the Court of Appeal. So you don't get into a disapplication at all. And there was a slight debate about mar leasing, disapplication, the differences, etc. The disapplication on this case would be a complete rewriting of the limitation provisions applying to the recovery of customs duty. Now, I don't know how you can do that and remain true to the principles of legal certainty, of foreseeability, fixing time limits in advance. Indeed, you cannot. As Zu Fleischhandel reminded us, that if it's going to be a judicial practice you rely on, it has to be a determined practice that is known and foreseeable. The idea is foreseeable here, that you would disapply 37(2)A, apply a 6-year period. I think my friend's fondest the number, and then apply 32(1)C to that is outside any foreseeable situation. I don't know if your lordship, I'm sure you haven't picked up the reference we made in our skeleton argument to the published documents of the revenue on the application of extended time limits, but they had stated on their website published information that at the relevant times till 2017 that a 3-year period would apply, but those cases involving mens rea fraud, that some other limit may apply. We have actually dug out the bits of the website if that's of any interest. We referred to it in our skeleton argument for the Court of Appeal. It's not a big point, but I say it in passing.
Not the published policy.
Published policies, indeed.
Yes.
It's not. I'm not trying to set up some legitimate expectation here with that. It's much more the legal certainty point, that you have published policies that say one thing, and it's really my Lord Reed's point when you say, well, you know, that's the effect of legal cases in all cases if you apply the principle of establishing the common law. But with time limits and such, it's rather different to that. And when you look at mar leasing cases, including the case my own friend relies upon, where you have enactments under UK law of an EU legislation, you have some conditions that are put in that are contrary to EU law. It's very easy to put your line through those and say, well, you've still got the basic right, and the preconditions that the legislature put in are contrary to EU law, and you mar lease them or disapply them. You can't do that in this context of my submission because of the principle of legal certainty. You want a very different situation indeed. I don't know if your lordships want the provisions in that are published, but we have copies if they're of any interest.
Yeah, well, by all means. Yes.
So I'll hand them up at the end, maybe. The other point I'm asked to mention, 2 points, is one, of course, the present code has been replaced by the UCC, my own friend of huge significance, but this is now outdated legislation. It's not applicable to new things. And the final thing is about a reference, I've been asked. Obviously, I'm not asking for a reference. I don't think there should be a reference. It doesn't need to be a reference. My own friend kind of flies a kite. It's obviously up to your lordship to say whether it's Act Clare or not. In my submission, you only have to draft the questions you'd ask the EU and read Velo Service and Zu Fleischhandel to know what the answers would likely to be. But unless you've got any questions on that, I was just going to mention that in passing, that that's something that my own friend puts in issue. Unless there are any questions, my lords, my lady, those are my submissions.
Thank you very much, Mr. Callender. Ms. Sloan, do you follow? Mr. Beale.
My lady, a few points in reply. I hope not half an hour's worth. Firstly, one of the issues that was raised was a 6-year period from the date of the debt. Now, of course, the 6-year period from the date of the customs declaration would be before the notification. But the 6-year period from the date where we found out about the fraud would run from February 2007 for 6 years, which would bring the notification within the scope of that. So yes, it is correct that we do need to invoke, if we get to this, section 32(1)(a) of the Limitation Act. That's capable of being invoked here because the concept of fraud encompasses not simply the fraud of the defendant, but the fraud of the defendant's agent. And of course, it was always part of the expectation that false and incorrect certificates of origin would be furnished to HMRC to enable the goods to be brought in at a lower rate of duty than otherwise would be the case. Limitation periods generally, there was some suggestion about the public policy behind them. We're not disputing that limitation periods generally are a good thing. Of course they are, that's why they're often set. But there are countervailing policy considerations, one of which is that a strict limitation period that wouldn't enable frauds to be detected is not a good thing. And that has an equally valid public policy perspective to it. Of course, what you can't do is ride roughshod over the rights of individual taxpayers, and our submissions seek to ensure that that balancing exercise is still conducted in that way. It's worth noting that in AGRA, as a matter of legal certainty, the 30-year period did not offend that principle. And so, as Mr. Justice Burst said in the upper tribunal, the practical distinction between a 30-year period and an indefinite period is one that is not great in practice. And of course, as a matter of legal certainty, if one's simply looking at what the national legislature has done here, what they've done is certain. You can foresee what the answer is. The answer is there is no limitation period. Section 37(2)(a) is foreseeable and ascertainable. It produces a result in which there is no domestic limitation period. And I can well understand why this taxpayer doesn't like that, because it's suddenly being asked to pay tax debts, customs debts, that are outside the scope of the 3-year rule. But if the proper construction of Article 2214 is that you defer to domestic legislation for the rules on the extinction of customs debt, which is what the court said in that, then the position you end up with is needing to identify a positive tenet of EU law that either imposes an obligation to impose a limitation period to stop, or one must consider what the scope of the principle of legal certainty requires vis-à-vis the legislation that's in place. Unless one is able to establish a clear positive duty to enact limitation periods as a matter of EU general principles, we are left in a position where legal certainty can be used defensively to the exercise of executive power that the Limitation Act otherwise permits HMRC to follow. So the real question here is how does one identify the relevant principle of EU law? Now, my learned friend took your lordships and your ladyship to FII and cited FII in passing as supporting his case. With the greatest respect, FII doesn't deal with this particular point, because FII was about the retroactive curtailment of a limitation period that had already been set. It is in additional bundle 1, tab 29. And if I could invite you, please, to turn briefly to the judgment speech of Lord Walker, paragraphs 94 to 96 in the electronic bundle. That is page 911. His Lordship said at paragraph 94, limitation periods must be reasonable, but the Court of Justice recognises that national systems vary a good deal, and accepts different approaches as long as there is no infringement of the principles of effectiveness and equivalence. So in essence, this is something that is dealt with routinely at a domestic level, and it's been dealt with here through section 37. Paragraph 95, His Lordship referred to cases at EU level where different conclusions have been reached about the reasonableness of a limitation period, one of which, see Emmett, was that there would in fact be no proper or effective limitation period because the time didn't begin to run until there had been correct transposition of the relevant directive. So long as a member state remained in breach of the directive, there was no time period that would be applied. So recognising you can have an open-ended limitation period as a matter of legal certainty, question mark, does that mean that can you challenge that open-ended nature of it by reference to a different principle, i.e. legal certainty? Well, the Nencini case makes clear that you can, but the consequence of that would be that you would strike down the indefinite nature of a limitation period on the basis that it didn't, in Nencini, you would impose a reasonable obligation to proceed on the exercise of the underlying power, rather than necessarily imposing a limitation period. And then in 96, Lord Walker refers then to the principles of effectiveness, equivalence, and legitimate expectation also apply if a national legislature enacts a measure to curtail an existing limitation period, especially if the measure appears to be directed at a particular ruling of the CJEU. And that goes back to the Marks and Spencer's case. Now, it was that principle which was engaged in FII in the same way as it was with Marks and Spencer, whereby you had an existing limitation period in each case. In Marks and Spencer's, in fact, there wasn't a limitation period. It was cut back in circumstances when insufficient transitional provisions were put in place to allow acquired rights. It was the impact on acquired rights of a taxpayer that was the subject matter of the reasoning of the Supreme Court in FII and of the CJEU and Marks and Spencer's. In each case, the infringement of legal certainty was because it trampled on existing acquired rights in a way that hadn't allowed them to be exercised in the meantime. And it was a facet of, essentially, legitimate expectations and also effectiveness, because it wasn't open to the taxpayer in question effectively to exercise their legal rights because of the curtailment of the limitation period without a transitional period. Now, in terms of whether or not a 3-year period is a reasonable period or not, if one is applying a reasonable period approach, then I fully accept that one way of looking at that as a default position would be to say that you, the revenue, have 3 years from the date of detection of fraud to bring together the additional communication, the additional customs debt that needs to take place. And that's certainly a viable way of starting off. You've seen from Nencini that one also needs to take into account other factors. Has the debtor's conduct contributed to the delay? Is there a good justification for an additional delay beyond that 3-year period? All of these issues could be dealt with at first instance. In this case, the way the case was presented was very much at first instance, it's an all or nothing. You've either put in place a limitation period or you haven't, and if you haven't, you lose the revenue. And it was very much put that way. There wasn't an alternative fallback that somehow the customs debt that was communicated in 2011, 4 years after the relevant mission from OLAF, was somehow a breach of a reasonable time principle. Now, if that's a problem, then my suggested solution with respect is that the matter will be remitted yet again. But it certainly shouldn't be an insuperable problem that isn't capable of being dealt with. What one would need to do is, well, there's two approaches essentially. Either there has been no objection to the reasonable period which has been taken for the second notification of the customs debt, or if that is something that could conceivably be taken, then it would have to be remitted for further findings. In terms of Article 2214, my learned friend puts his case very much as a power case. You have my primary submission that this isn't a power case. This is a case in which the structure of the legislation, unlike the UCC, is not, well, you can have an extension if you exercise a power under domestic law. Article 2214 says in turn, you may notify the customs debt after the expiry of the 3-year period if this is as a result of a criminal act. And so the only condition is that you have to show that it's the result of a criminal act after that, si agri, you default to the domestic law provisions such as they are. Now, the domestic law provisions we have say there is no limitation period for collection of customs duties in that situation. So what one then needs to find is not some restraint on the exercise of the notification by the commissioners as a result of the legislation. One needs to find a restraint as a result of a general principle of EU law. And that's where legal certainty obviously comes in. And that's how my learned friend puts his case. It's important to bear in mind that that is not a constraint that the EU legislation has put in place. It's a constraint that arises from the UK's obligation to comply with general principles of EU law, which arises when we implement the scope of EU law. Article 2214, we say, is not an extension provision, it's a division of competence provision. And it defers to national law to decide what the applicable limitation period would be. Now, the limitation issue in Molen Marty, which my learned friend said was issue 3 in that particular reference. In fact, issue 3 was dealing with the question of which set of limitation rules applied, because as often in these cases, there was a change of regime. The issue was, is the limitation period that's prescribed a procedural law, so that a change in the law applies equally to cases that exist and are ongoing, or was it a substantive rule, in which case it couldn't have retroactive effect? In that case, they found that the provision in question was a substantive bar, the 3-year period was a substantive bar, and see paragraph 39. And so that, therefore, necessarily meant that the provisions in force had to only apply because it was a substantive extinction of a debt. So you applied the... In terms of fixing the limitation period in advance, here, if the complaint is made that you haven't fixed a limitation period in advance, the short answer to that point is, well, we have. But we fixed a limitation period that has no limitation. If the suggestion is there is a principle of EU law that requires you in all circumstances to put in place a limitation period, then it was incumbent really on my learned friend to identify it. And it's apparent from the state aid cases that no such general obligation exists, because otherwise those cases couldn't be decided whether they were. The highlight of his case actually is one case, which is the Fleischhandel case, which, as I sought to explain in opening, is very much dependent upon the actual wording of the regulation in that case. That was a case where the regulation said you can have a different limitation period from the 4 years if you retain it in your domestic law. That necessarily presupposes that there is in domestic law a limitation period which you can apply. So it's akin, in essence, to the UCC provisions, which say you can have between 5 and 10 years, and it's incumbent then on the member state to pick what the period is between 5 and 10 years. That isn't the case with 2214, which simply defers to the domestic legal order to consider what limitation period is applicable. The foreseeability issue, in terms of disapplication, I'll come on to at the end, because actually it arose as a result of a question from the bench, but I'll deal with disapplication as ground four right at the end. Fleischhandel itself, of course, as I not so sotto voce invited my learned friend to do, concerned a legal regime that was only introduced in 1995. There was no limitation period in effect before 1995. You simply deferred to the national regimes for what the limitation would be, for example, on recovery of export refunds that have been retained. So it's actually a classic example of the court not saying that the previous regime was unlawful. What they're saying is the 1995 regulation has introduced a measure of harmonisation. And where it hasn't harmonised, it defers expressly to national legal provisions that are in force and can be retained. So it's expressly recognising that if you've got a different limitation period, you must keep on applying. But you would necessarily have to have a national procedure to oust the general rule, otherwise the general rule would apply. In contrast, in our case, you have a general rule. It's ousted by the factual fact, the factual circumstance of it being a criminal case, and that's enough to take it outside the ambit of the 3-year period, and you then have to look exclusively to national law as to what the limitation period would be. And that's made clear from, for example, paragraph 50 of the judgment in that case, in the Fleischhandel case. The Fleischhandel determination itself, and this is where my learned friend alighted on some paragraphs that deal with, it's not for the court to remake what the limitation period would be. Fleischhandel was instructive for 2 reasons. Firstly, they found that the 30-year period was in fact reasonably foreseeable if it followed from a judicial practice. And therefore, what scuppered the legislation was not legal certainty, it was proportionality. And so the court's finding on not being prepared to remake the legislation was that they weren't prepared to indicate what a proportionate limitation period would be. And that, with a great respect, is unsurprising. The setting of the limitation period, as the Advocate General's opinion makes clear, involves balancing a variety of different considerations, balancing competing interests, balancing budgetary constraints on member states and the EU versus the rights of the individual taxpayer. And that isn't something that the court will willingly engage with. So having found that 30 years was disproportionate, it wasn't prepared to say, but we would rule 10 years was proportionate, in the same way that the House of Lords in Fleming wasn't prepared to allow the UK government the benefit of what would be a proportionate transition period without having to be enacted. So you end up with a position whereby the court will indicate what is reasonably foreseeable and what is disproportionate, but it won't actually tell you then how to cure it. But as a matter of legal certainty, which this case is about, what is apparent is that you could have a position where, in fact, the domestic limitation period was foreseeable and ascertainable, but provided for no limitation. And the constraint then would not be that that somehow infringes legal certainty. The constraint would be it enables the taxpayers' affairs to be open to challenge for an indefinitely long period. And that's really the true principle my own friends are lighting.
And that's disproportionate.
No, that goes to a different aspect of legal certainty, which is in order to cut down a domestic limitation period on the basis that it simply doesn't allow the affairs to be corrected sufficiently soon. The answer to that would not be to invalidate the Act of Parliament on that basis. It would be to constrain the act of executive power. It's the notification of the customs debt that then can then be constrained by reference to that principle. Because what one would say would be, you, the customs authority, are issuing a customs demand too far after the event so that the taxpayer isn't in the position to be able to respond to it. So it infringes the rights of the defence. It's that aspect of legal certainty that my learned friend actually is alighting upon. And that is akin to the stale claims that Mr. Justice Burse has referred to, and it's akin to the Nencini, you've simply left this too late, you've sat on your hands too long. Now, insofar as it was a challenge based on proportionality, that would have had to be raised. That isn't the line of challenge that's been taken. Had it been, we would have had evidence as to the impact or inconvenience on this particular trader and having to face an additional 8 or 9 months bills over and above the determination that had already been taken place for the 2 years in question. So what happened in this case was obviously we lodged a customs demand that was in time. We then had the determination of the Article 220 issues so that in fact the customs debt wasn't waived. We had confirmation that the fraud had operated in the way that OLAC had indicated, which was challenged in the first case. Having established that fraud, having established that there was no waiver of the customs duty, my clients then imposed a second charge which went back, I think, 10 or 11 months for the previous year, to the point at which the consignment started. So in other words, we'd detected the fraud, we'd established the fraud to the satisfaction of the tribunal, and that then enabled us to go back and deal with the early months in question. Now, if this was a proportionality analysis, one would have to balance the impediment to the taxpayer from that additional demand against the benefit to the public purse and the EU budget of having the additional money in, and actually making sure that the full effect of the fraud is counted. Next point my learned friend said is, one of the questions here is whether or not we can enact a provision which deals with what he describes as a power under 2214. The short point there is we have enacted a provision. We've enacted a provision that says there's no limitation, and it's really incumbent upon the taxpayer in this case to show the principle of EU law that sets that judgment aside and trumps over the provision of parliamentary sovereignty in the standard way. Some notes. Velo service. The point about velo service was that there was no limitation period for Article 78. Recognised that there was no point redoing a customs declaration if in fact the debt was already extinguished. Crucially, at paragraph 37, they didn't say that that would be capable of operating as an impediment to readjusting the customs declaration if you could rely on 2214 because it was a criminal act. They said that particular 3-year period for adjusting declarations wouldn't apply where the conduct in question was the result of a criminal act. They didn't say, and by the way, you have to put in place a limitation period specifically for Article 78. It simply said, in those circumstances, the 3-year period wouldn't be an impediment to the operation of Article 78. And so, in fact, we say it falls 4 square behind our submissions on the proper construction of 2214. The next point was, my learned friend, as my Lord Hodge indicated, made repeated differentiation between EU institutions and UK institutions. With the greatest respect, there is no rhyme nor reason why the principle of legal certainty shouldn't apply equally to each. There are certain general principles of law in the Charter, for example, which only apply to institutions. But that's made clear on the basis of the legislation. Here, my learned friend necessarily needs to import the constraints of legal certainty precisely against us as an authority of a member state. But at the very least, it has to be the same principles that are applied, because these are general principles of EU law. And what you don't find, for example, in Professor Tridimas's book, is a whole section devoted solely to general principles for domestic authorities and those devoted to EU institutions. I also balk slightly, with the greatest of respect, at the idea that legal certainty gets compartmentalised into different categories. True it is that there are different manifestations of the principle in EU law, but they all have at their core the requirement for individuals governed by the rule of law to know where they stand. And that is the common theme before each. Limitation periods no doubt reflect a concern about legal certainty so that you don't have matters open-ended for too long, but what one needs to identify is the specific provision of legal certainty that is said requires a limitation period to be put in place, as opposed to constraining the exercise of executive power if none is put in place. Moving on then to ground 3 and 4. Ground 3 essentially focuses on, are there any reasons why taxpayers' affairs won't be open for an indefinitely long period, if that is the correct test for what the legal certainty principle requires? Answer, yes, there are a host of domestic law and indeed charter pieces of provisions of law which are capable of being brought to bear by the taxpayer to stop his affairs being indefinitely open. Similarly, disapplication. The purpose there is to give effect to what by this stage on ground 4 is an identified EU law right which trumps section 37. And if that is where we have got to on disapplication, then if the concern is, well, the absence of a limitation period is the problem, then disapplication of section 37 cures that problem. And it isn't a case of, oh, well, that's very unfair on a taxpayer because it's not foreseeable. it's a necessary consequence of a challenge to an act of Parliament that disapplication will be the primary outcome because of the balance between parliamentary sovereignty and the supremacy of EU law. And that's the sense that the pact that's been made by Parliament under the European Communities Act. It's no less foreseeable that the outcome should be the disapplication of the offending provision of domestic law, simply because this is the first case through the court system, in the same way that repertoire culinaire was the first case through the court system challenging the UK Parliament's approach to the implementation of an exemption under the Excise Directive. In that case, nobody else had come before the courts and said, we don't like these conditions. Repertoire culinaire was the first one through the gates to say these conditions are disproportionate, therefore they should be disapplied. And it was therefore reasonably foreseeable, as the Court of Appeal held, that the consequence of that would be that the conditions would be disapplied, but the bits of UK legislation which did not offend a directly effective EU law right would be applied. That's the trade-off between parliamentary sovereignty and supremacy. That was foreseeable, and the court rejected any suggestion that they were somehow legislating to give effect to a different outcome. They overturned the upper tribunal's conclusion to that effect. And I should add, for the sake of completeness, that this court refused repertoire culinaire permission to appeal in that case. Do you give me a moment? I do not have my metaphorical gown being tugged, so unless you have any further questions, that's it from me.
Could I just ask you in relation to section 37(2)(a), proceedings, as far as tax is concerned, although there isn't a limit, as we can see, there's no limitation period applicable to the recovery of tax, there are quite strict time limits on the assessment of tax. I mean, what's going through my mind is that it may not be right to view 37(2)(a) as implying some sort of policy that the HMRC have indefinite periods of time to recover taxes. In the tax context, they would have to issue an assessment within specified time limits, and you can then appeal against the assessment. So far as, and the other category is of course duty. As far as that's concerned, that's really what we've been looking at. There is a time limit applicable normally under EU legislation, and it may be that the situation we're dealing with is the only one where there would be no applicable time limit on your submission.
It's absolutely correct that there are other, usually primary pieces of legislation which set time limits for example, the assessment and therefore de facto the recovery of indirect and direct taxes.
Yeah.
And in this case cites a number of them, and you've not heard me contradict what he says. That nonetheless leaves open the fact that for everything else not covered expressly by a piece of primary legislation, the general limitation regime is ousted where it involves the proceedings by the Crown for the recovery of any tax or duty.
Yeah.
Now, it may be that in practical terms that is only customs duty. So be it. Parliament legislated at a time when a different version of the Customs Code was in place. But this hasn't been changed since the 1992 Customs Regulation was put in place. And Parliament means what it says.
Yeah.
It's something on which I think Lord Houghton and Lord Sumption agree. So that's where we are. That is what Parliament says. If it applies to customs duty, it applies to customs duty. If there is nothing in the Community Customs Code that says that you have to put in place a limitation period under 2214, then that's where we are.
Thank you very much, Mr. Beale. Well, we're very grateful to all counsel for very helpful submissions. We'll try to work out now what the answer is.
Well, do you want me to hand up this, or through the channels, the published information on that?
Yes, you can give it to our usher after we've risen. Thank you.